Welcome to the Under Oath podcast with your host, Rich Lomurro. On Under Oath, you go inside America's most famous cases with the people who tried them. From O.J. Simpson's murder trial.
We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder.
To the Deep Throat pornography case.
Deep Throat succeeded because the government went after it.
Our special guests take the stand and reveal their stories. Under Oath, live from the courtroom at Lomurro Law in Freehold, New Jersey. Here is Rich Lomurro.
Hi everybody, welcome back to Under Oath. We're picking up our interview with Tom Mesereau, who is going to finish telling us about the Michael Jackson trial, and then he's going to tell us about the Bill Cosby trial. He most recently represented Bill Cosby. And then he's going to finish up telling us about some pro bono projects and capital murder cases that he handled in the Deep South. And excited to get you this episode. So the recording is much better than the last one. I play around. Sometimes it's by phone, sometimes it's by Skype, sometimes it's call recorder on my phone. And, you know, the quality goes here and there. Sometimes it's better. This one is better, and I'm happy that that you can hear him a little bit better. So please enjoy Tom Mesereau. I don't have another show lined up. I was going to kind of end this thing because I thought it was a great body of work, and I've always tried to focus this podcast on quality, not quantity. I think that a lot of the podcasts out there have too many episodes and not necessarily the best content, and I always wanted to keep this as a quality podcast. But to my delight, a lot of people have encouraged me to keep going and try and find some new guests, keep the podcast rolling. And that does not mean I'm going to deviate from the quality. I'm going to keep the quality a top level show with only the most famous cases being considered and guests who are worthy of your audience. So here is Tom Mesereau, and I hope you have enjoyed Under Oath. I'm looking forward to keeping it going. I'll let you know when the next episode is. Your best bet is to check on social media, Twitter, Facebook, and that's about it. Not great at any of it, but I'm going to try and keep this thing going and maybe pick up some more momentum. Thank you always for listening. We'll see you next time. Enjoy this episode with Tom Mesereau. So, how are you?
I'm doing all right.
All right.
Ready to go.
I figured we'd pick things up where we left off. You had told me that you had a funny story about closing arguments in the Michael Jackson case. I was hoping you could share that with us.
Sure. Are we going forward now?
Right now, we're on.
Okay. I told you there was an amusing story about closing arguments in the Michael Jackson case, and let me explain it to you. It starts with opening statements. I gave a very aggressive opening statement. I did not mention burden of proof. I did not mention reasonable doubt. I did not mention presumption of innocence. I got up and I looked at the jury and I said, I'm going to prove to you that this man's innocent. And I went even further than that. I said, I'm going to make a contract with you, and I want you to hold me to my contract. I will prove this man is innocent. And what happened was the trial was expected to be about 8 or 9 months. I had a feeling that we were doing quite well and that the jury really got the message and that they wanted to, end the testimony and start deliberations. And I felt we were in good shape. So I shortened the trial by a couple of months by cutting off a lot of witnesses who I originally planned to call if necessary, but decided we didn't need them.
What's an example of one of those witnesses?
Well,
character witnesses?
Yeah, well, not character. We didn't introduce any character witnesses in the case. But I had witnesses who had worked with Michael, who thought highly of him, who never saw anything improper. And there were a number of people I still could call. But nevertheless, I felt really it was time to get it to the jury. We were in pretty good shape.
Okay.
As good shape as I thought we were ever going to be in. So we ended up in closing arguments. The prosecutor got up, and he had a list of things that Mesereau allegedly said in his opening statement that he had not proven. And he reminded them that I said I was going to prove certain things. And he talked about people I didn't call and things that I said I would prove that he claimed I hadn't. And he finished his closing argument, and under California procedure, the prosecution goes first. They give a closing, then the defense gives a closing, then the then the prosecutor gets a rebuttal. There's no rebuttal for the defense. You can ask for it, but you generally don't get it. So I had my one shot. So I got up for my closing argument, and I looked at the jury. I said, when a prosecutor begins his closing argument by attacking the defense lawyer, you know they're in trouble.
Yeah, that's great. That's true. Absolutely.
And gave my closing argument. I noticed the prosecution was sort of grouping together, perhaps to change something. And the prosecutor got up for his rebuttal and had a series of overheads that he was going to show, charts, pictures, that kind of thing. And he accidentally put on a visual that said, "Promises Mesereau made," and then quickly took it off. And it was obvious they had changed their strategy, that I had rattled them in the way I began my closing. And just so you know, this was going to be a long trial. There were going to be a lot of unexpected twists and turns that nobody could predict. And my approach to opening statement is always be aggressive. If you have to change tactics or change strategy, that's something that you will do. But be aggressive. Don't undersell. Don't walk on pins and needles. Don't walk on eggshells. Come across as a bearer of truth. Come across with courage. Be aggressive. Be professional, but be aggressive. And let them know that the truth is on your side and you're not afraid of it.
What if, in this situation, did you draw an objection by making those statements? Are clearly argumentative, and I know you say forget about it. You got to argue, and I agree with that. But what if there's it seems like an objection to me.
Look, I think that everything you do in a trial is argument in one form or another. I mean, where the convention originated that says opening statement is not argument, I don't know. But I do know that opening statement is an argument. Just look at what prosecutors say. They essentially call the defendant every name in the book. They assassinate the defendant. They dehumanize the defendant. They accuse the defendant of a crime. They go through the elements that they say prove their case. Try and tell me that's not argument.
Yeah, but they usually, for some reason, don't get protected, or they do get protected by the court. We don't, as defense attorneys, generally.
Well, that's why we have to develop methods for disguising what is really an argument.
Okay. By saying I will prove, right?
I always say I will prove. I try not to ever say the evidence will show, or at the end of this trial you will conclude. I try to say right away I will prove. I think it looks more honest. I think it sounds more plausible. I think when the defense lawyer starts off by talking about burden of proof, presumption of innocence, reasonable doubt, I think the typical jurist says, that's a trickster. He's hiding behind legal concepts. His client's probably guilty, but he thinks he can block it through technicalities. I don't want them to suspect that for me.
Right.
And that's what happened in the Jackson case. They got really rattled when I exposed them for what they were doing.
So did they change their game up at that point?
Well, they changed it up in the rebuttal, but accidentally goofed and showed the wrong slide and quickly took it down.
When did you know you had them? Did you know it before you got the verdict sheet? Did you feel that good?
I felt that there would not be conviction. I didn't think 12 of these jurors would convict. I didn't know if they would be acquittal.
Thought you might hang them.
I certainly hope so. The jury went out on a Friday and were out the entire next week and came back the following Monday with their verdict. There were essentially 14 charges. There were 10 indicted felony counts, and the judge, without being requested by the prosecution or the defense, instructed the jury on lesser included offenses for the last 4 felony counts. He told them that if you find the defendant is not guilty of the felony count, you then can consider the lesser included misdemeanor count.
Do you think he was giving them an avenue at a softer sentence, or was he just being, aggressive on his own?
I think he thought the prosecution might have some problems, and he wanted to give them something.
Yeah. Probably inappropriate, right? Doesn't the prosecutor have to make that request, or defense counsel?
We don't have to make that request at all, and nobody did make it.
Right. So a sua sponte order by the judge to consider lesser included offenses.
Yeah, the last 4 felony counts were essentially charging Michael Jackson with giving alcohol to an underage child to prepare them to be molested. And what the judge did was said, if you find he's not guilty of any of those 4 similar felony counts, you may consider a lesser included misdemeanor, which is giving alcohol to an underage person.
And they didn't find that either. Clean sweep every single charge, not guilty, right?
Yeah.
How was the aftermath?
Well, it was craziness. I mean, I lived in northern Santa Barbara County, which is north of Los Angeles County, where I live and practice. I lived up there for 6 months, and I lived like a hermit. More accredited media covered the trial than any trial in American history. There were more accredited media than O.J. Simpson and Scott Peterson combined.
It's crazy.
And I sensed danger everywhere I went, that people really wanted to see Michael Jackson convicted in the media because it made for great stories.
Did you feel that, when you went to dinner, when you went to the grocery store? Did you feel that everywhere?
I did, and what the media quickly realized about me was that my lights went out at 7:30, latest 8 o'clock every night, and my lights went on at 3 in the morning in my condo, and you couldn't find me in a hotel or a restaurant or a bar or on the street in the evening.
So you weren't a attractive target for them. They kind of just probably gave up on you, I bet.
They kind of gave up. They followed me around when they could, but I basically, went to and from court and stayed, in my quarters, which was a duplex. My co-counsel and staff had their duplexes, and we had one duplex, which we called the War Room, which had about 30 computers and thousands of volumes of documents. And my staff had a key to my duplex, and they were up all night updating witness books. For every witness, I like to have 3-ring binders with every document that references the witness in chronological order. And those documents can be police reports, newspaper articles, investigators' notes, declarations, pleadings, whatever it is.
Right.
I like to have them in chronological order, so when I go through them, it helps me see patterns or see changes and try to explain the changes in testimony or recollection, whatever it may be.
Right.
So staff had a key to my duplex. They were up all night updating these witness books, and every hour of the evening they'd be opening my door and dropping updated binders on my stairwell. When I got up at 3 o'clock, I would look down my stairs and just see all these binders of updated witness books. And I would do 3 or 3.5 hours of work in the morning before I went to court.
Wow, that's incredibly interesting. And the staff, so they would break it down for you, and then you would digest it in the early hours of the morning, be ready to go the next day.
Well, in addition to whatever else I had done. But we were getting late discovery from the prosecution. They always seemed to be dropping more documents on us.
Where did Michael Jackson stay during the whole thing? He couldn't have stayed at Neverland, right?
No, he did.
He did? That's a pretty bold move.
He stayed at Neverland. He got up real early in the morning. He was a very nocturnal person. He would sometimes be walking through Neverland at 4 in the morning. But he would get up and prepare for the day's work as best he could and be chauffeured in Neverland. He was out on bond. And it was a very, very difficult, exhaustive process for him.
What was communication like between you and Michael throughout the trial? Was he really in every stage of it, or did he say, Tom, you're the guy, I'll sit back, you do your thing?
He was extremely attentive. He would be writing notes, not, all the time, but some of the time. He was a very good listener. He was very respectful. In fact, after the acquittals, I went on Larry King for an hour, and Larry King asked me if I had talked to any of the jurors. I said no, but I'd love to. And then I got a call from a juror who was the foreperson saying a bunch of us would be happy to meet with you. We saw you on Larry King expressing interest. And when I met with them, one of the things the foreman told me was that he said every time we looked at the defense side, whether the testimony was good or not good for you guys, you all were so professional. Michael would just sit there, very, very respectful. Nobody was rolling their eyes, pulling their seat back, shrugging their shoulders, trying to make a phony type of impression. He said, on the other hand, the prosecutors were always rolling their eyes, swiveling their head, pushing their chairs back, trying to impress us, and we didn't like it.
They're observant people, jurors.
Absolutely.
Yeah.
They know their job is a serious one.
No doubt. So after the trial, did Michael Jackson kind of disappear as far as your relationship goes? Or, I mean, I know you said he was physically just beaten from the process.
Well, what happened was I advised him to leave Neverland and not return. And there was some resistance, but I said, look, I've lived up here for 6 months. I've seen and felt what's been going on. I said, when we got into the case, it was obvious these prosecutors and these police were feeling no pain. They felt they were on top of the world, that there was no way they could lose this case. It was going to be the most watched trial in American history. And I said, they are humiliated and embarrassed, and they're going to be desperate to pin another case on you.
Right.
I told them that you're never going to live in peace. The days of Neverland, as beautiful as it is, as relaxing as it is your refuge, your Mecca, but those days are over. Mm-hmm. I said everything has a time and place in life, and Neverland's place has come and gone. You're always going to be living on pins and needles, wondering if they're going to do something to you. You can't live here. So I didn't know he was going to move to Bahrain in the Middle East. One day he started calling our office, and he had moved to Bahrain. And for the next 9 months, my former partner and I helped him with some of the issues involving resettling in the Middle East. My law partner was helping him with business matters, selling animals, selling amusement rides, whatever it was.
Right.
And then after about 9 months, we stopped doing work with Michael and weren't in much contact with him after that.
And we all know how tragic his story ended.
Just terrible.
Yeah, it really is. Do you credit some of his turmoil to what happened, or is it just kind of part of a puzzle that nobody will really ever understand?
I don't think he ever recovered from that trial.
Sad.
I think, when you get to know Michael, you find out that he's a very, very sensitive, kind, intuitive, artistic individual, and not really built for a court proceeding like that. He was a musical genius, a genius at choreography, dance. Fred Astaire called him the best dancer that ever lived, and he never took a dance lesson. But he really was continually bewildered how anybody could say that he organized a conspiracy to extort a family, falsely imprison a family, abduct children, that accusing him of supplying a cancer-stricken child with alcohol and then molesting the child. He just could not understand how anybody could even concoct such accusations. And as the trial went on, he seemed to really lose weight and deteriorate physically and emotionally. Mentally, he was there. I would talk to him early in the morning, sometimes 4 o'clock, 4:30, 3:30, because, as I said before, he was a very nocturnal person. But I don't think he ever recovered from the trauma of all of that. And then the trauma of having to leave Neverland, which he loved, moved. He tried settling in the Middle East. It didn't work. He tried Ireland. He tried France and England. He then came back and lived in Las Vegas. He then moved to Los Angeles to prepare for his comeback. And then, unfortunately, disaster struck, and he died from the drugs that he was being given.
Right. One more Michael Jackson question, and then we'll move on to Bill Cosby, and then I'd like for you to end our show talking about your pro bono work. My last Michael Jackson question is, Michael Jackson famously wore pajamas to court one day. What was your take? I mean, you obviously wanted Michael Jackson to be Michael Jackson. You didn't want to have him be someone he wasn't. What was your strategy in allowing, or just kind of not jumping up and down when he came in pajamas?
Well, I'm responsible for that because I got a call that Michael Jackson had been taking a walk in the wee hours of the morning. I think it was around 3:30 or 4, tripped and injured his back. And he was taken to the hospital where he was under a physician's care. And I went to the judge and asked if he would delay proceedings, and the judge refused. He said, if your client's not here in 30 minutes, I'm going to yank his bail and arrest him. And so I got on the phone with Michael and his people, and I told them, I said, look, this judge means business. He's not sympathetic. I even offered to put the doctor on the line with the judge. The judge didn't want to talk to the doctor. So I said, you can't go home and change. You've got to get here. I don't care what you're wearing. So he showed up with a jacket and pajamas underneath the jacket. He sat at counsel table, and when the jury came in, he was sitting there, with a shirt and his jacket. And according to the jurors after the trial, they didn't even notice his pajama bottom.
That's interesting.
Yeah, so that really was my doing. I didn't want to risk him being remanded.
That's such a different. I've seen the pictures. I think I've heard the stories behind it, but I did not know that there. That's a logical explanation for it. So that's interesting.
That's exactly what happened.
So years later, very recently, you represented Bill Cosby. Tell us how you got into that case.
I was approached by people around Mr. Cosby. They knew my reputation in the Jackson case. They knew my reputation in Los Angeles. And I'd won a number of white-collar cases in federal court. I'd won a number of cases in state court, non-white-collar criminal cases. And they've been following my career, and they asked me to represent them, and I agreed to.
What was the interview process like for that? Did you actually go and meet Bill Cosby? I mean, I'm still blown away by your Michael Jackson interview, so I'm just curious.
Yes, I did. And, he always remained the same person. Very, very nice to talk to, very respectful, very decent, very considerate. I can only say good things about him, and I tell the truth. He was a very decent guy to be around and to represent.
So there's a very muddy history with the Bill Cosby case. He has an assurance from the DA a long time ago, I guess in the 80s, that they're not going to press charges against him, which then motivates him to go and give a civil deposition talking about allegations by his accuser. Obviously, nobody would agree to take that deposition if they had a criminal offense hanging over their head. They'd plead the fifth. So tell me a little bit about that.
Well, it actually happened around 2004. An accusation was made by the alleged victim that she had been sexually assaulted. The then existing district attorney for Montgomery County, Pennsylvania, looked at the evidence and decided he was not going to go forward with the case. He informed Mr. Cosby's attorneys that he was not going to prosecute, and he reached an agreement on behalf of the district attorney's office not to prosecute. And he went further than that. He told Mr. Cosby's lawyers that he had no Fifth Amendment privilege to avoid the civil deposition because he would not be prosecuted criminally. And, of course, I was not involved in any of that, and I didn't know Mr. Cosby at the time. But my understanding is that on the basis of that agreement, they went forward with a deposition. Now, there's something else you need to know. When that DA was running for district attorney, it was a nasty election.
Yes.
And his opponents were really going after one another. And my understanding is the opponents felt that his opponent, who became the DA, tried to hurt his reputation by allegedly bringing a girl to a debate that the opponent supposedly had an affair with. Now, that opponent turned out to be our trial judge. So what happened was the district attorney made an agreement not to prosecute. He lost the next election. His opponent was putting ads on TV that if elected, he'd go after Mr. Cosby, despite the agreement. That's exactly what happened. So the defense made a motion to throw the charges out based on the prior DA's agreement. That prior DA testified under oath that he made the agreement. His former opponent in that bitter election was now the judge, and the judge, instead of recusing himself, made a finding that the prior DA lacked credibility and denied the motion.
So you moved for him to recuse himself?
We moved to recuse himself. The prior defense team had not, because in addition to the history I just outlined, the trial judge was married to a very highly regarded sexual assault counselor who taught and worked at local universities, and we discovered had helped to raise some funds to give to a group that was opposing us outside the courthouse. The judge refused to recuse himself. It gets even worse than that.
That's pretty bad, Tom.
Well, we went through all of the phone records of the alleged victim and Mr. Cosby. We also got his travel records and his travel itinerary. And we proved that this could not have happened when it was alleged it happened. Every day was accounted for. The phone calls that supposedly were made had not been made during that particular January. And we moved to dismiss the charges based on statute of limitations. We had all the evidence in front of us. The judge refused to grant a hearing on statute of limitations and refused to rule on it, even though it's a jurisdictional issue. His feeling was the jury can decide it.
On a statute of limitations, the jury decides.
Yeah, so we introduced all the evidence, and by Pennsylvania law, he could give a special interrogatory to the jury where they had to specifically find that the prosecution had proven beyond a reasonable doubt that there was no statute of limitations issue. He refused to do that. Instead, he read them an instruction that was buried in another instruction, and it never went into the jury room. So this judge, in my opinion, did everything he could possibly do to avoid addressing a serious, proven jurisdictional defect in the case. But it also gets farther and farther from there because it's bad and worse. During jury selection, one dismissed juror contacted us and said another juror had reportedly made a statement that he's guilty and deliberations won't be long. We had a hearing, and the judge refused to release that juror.
That was pre-trial as well?
That was while the jury was being selected.
Wow.
Yeah. Then, as I think you know, there was the issue of 404B witnesses who supposedly were testifying to similar pattern or occurrence. In the first trial, which hung, he allowed one such witness in. Now he upped it to 5 without giving any reasons for it.
Was there heavy litigation on that issue before the trial?
Yeah.
Okay. Yeah. I figured
Yeah.
very much.
Yes, and one of those women blurted out words to the effect he's a serial rapist.
Oh,
the judge
boy.
wouldn't give a mistrial. Another one of those 5 women said, "You know what you did to me with Mr. Cosby." Words to that effect. He wouldn't grant a mistrial. He continually cut off our cross-examination. He wouldn't let us call certain witnesses we felt helped prove our theory of the defense, which was that this was about money. Then in closing argument, prosecutor personally vouched repeatedly, saying, "I looked at this stuff myself." We asked for mistrial on a number of occasions for personal vouching. Judge wouldn't grant the mistrial. It was an absolute travesty of justice, in my opinion. It was the most unfair trial I've ever been part of.
I was going to ask you that. Have you ever felt the cards to be that stacked against you in your career?
No, I haven't. And I've tried capital murder cases in Alabama for the last 20 years, and I'll tell you, I've never seen anyone behave as badly as this judge behaved in any of those cases.
So what's the solution then, Tom? Because you and I know well that an appeal will leave Bill Cosby in jail possibly till he's dead.
Well, I'm not part of the appellate team. After the convictions, our team resigned and other lawyers took over to handle sentencing, and now they're out and there's a new appellate team. My hope is that they will get this done as quickly as humanly possible, because there are so many valid appellate issues that need to be addressed.
But it's never fast. It's never fast. It's never that fast. And you know, this is the way I look at it from the outside is this judge and this prosecutor could just take the position, we didn't care, we were going to hang him, and by the time it gets, you know, appealed, we've done our task. The public thinks that we got the guy, and he's so old that he may pass in jail.
Well, I mean, two of the young prosecutors who tried the case have since left to join civil firms.
Yeah.
I assume the DA is going to try and run for higher office. I would assume the judge will try and obtain a higher position, Court of Appeals or whatever. And I think what you're saying has a lot of validity to it. I think it was a travesty. I think people wanted their high-profile trial. They were not going to look at any evidence that suggested it shouldn't go forward, and it was a disgrace.
Was there ever a thought to put Bill Cosby on the stand?
Oh, sure. You're always considering whether or not to put a client on the stand. You do that in every trial, at least I do.
Sure.
But I think a decision was made that it wasn't necessary. We felt that we had done enough, despite the unfairness of the trial, to damage various, witnesses' credibility, to damage the prosecution's presentation, and a decision was made, like it has to be in every criminal trial, whether or not you need to put a defendant on the stand.
Did you have 5 trials within the trial for each one of the women who were allowed to come in and bring their story to prove, the 404B issues that should have been excluded?
Well, how are you going to do that when women are testifying to what allegedly happened 30 years ago?
Yeah, that's why I'm asking you. How did you address that?
Well, it's very difficult. You get whatever evidence you can. You investigate as best you can. But the fact is, nobody can go back 30 years and figure out who this witness was, as opposed to who they are now, and find recipient witnesses to whatever allegedly happened. It's, in my opinion, a travesty of justice.
Yeah, you certainly had your hands full with this one. Did you move out to Philly during the process of it and handle the case out here?
I moved to Montgomery County, Pennsylvania, which is outside of Philadelphia. Yeah.
Same type of thing as a Michael Jackson. You had a team with you working things up.
Yeah. An excellent team. I've never seen a better defense team in my life. We had terrific lawyers.
So how did you guys work in conjunction with Bill Cosby through the trial? He was out, right? He was out on bail too.
He was out on bond. He was at home. He was very accessible, very cooperative, delightful person to work with. And I believe everything he's had to say. I mean, I believe he's innocent. I believe a lot of this was nonsense. And I believe that we live in a very scary time where a movement like Me Too, despite their many good intentions and despite many good things they've stood for, has gone to excess. And I think judges are running scared, public officials are running scared, and this is a time when defense attorneys have to really assert themselves and not let injustice take over. Our country has had other periods in its history like this. Sure. We rounded up Japanese on the eve of World War II and put them in camps, took them out of their homes, their businesses were ruined. We've seen the country at times, because we're all human, go to excess because of some perceived threat. And, I really believe that he didn't get a fair trial for many different reasons, including the fact that this judge wanted a conviction and was not willing to stand up to Me Too at all.
Yeah, I think social movements all the way back to the Salem witch trial, right? I mean, they've been part of our country's fabric.
Absolutely. I mean, look, we criminal offense lawyers have done more to preserve freedom than any group I know, even though we're not always understood or liked. And, John Adams, during the Boston Massacre, so all these young British troopers being rounded up and charged with murder, and he said, look, they're not all guilty. And he volunteered to defend many of them. This is someone who was going to be the future president of the United States, and many were acquitted. And what he did was not popular. So if you really look carefully at this issue in American history, you'll see that there always have been criminal offense attorneys who bucked the trend and stood up for justice and due process and freedom when tremendous social pressure existed to whittle it away.
Yeah, this and these type of cases, the Bill Cosby case specifically, is a very hard case to try with that type of movement going on because it's a he said, she said fight in the courtroom. There was no hard evidence in that case.
Well, the prosecution had their testimony. They had their what they call circumstantial evidence to contribute to their position. But, it was a very difficult time to try the case. I'm not making excuses. I'm just telling you that this is the kind of period where defense attorneys have to really go to war and try and stop the impact on freedom and due process and justice, which powerful, passionate social movements always run the risk of doing. I'm very proud that we represented him, very proud to defend him, very wonderful guy to deal with, and I hope everything gets thrown out because he's not guilty.
How were things different in the Bill Cosby case than the Michael Jackson case? What's the most glaring example?
Well, the Bill Cosby trial was 2 weeks. The Michael Jackson trial was 5 months.
Why was it so fast, the Bill Cosby trial? They pushed it across?
I mean, every case is different. They put on whatever case they thought they needed to. And this was a retrial, whereas the Michael Jackson case was not a retrial. Prosecutors, traditionally gain in a retrial, not always. But that seems to be the trend in general. But it just was a different case, different people, different chemistry, different witnesses,
2 weeks
Every trial is unique.
2 weeks is not a long time for a trial. It's not a long time at all.
Right.
I wonder, was the temperature from the gate a more challenging one in Bill Cosby's? Because especially with all this evidence that was coming in, 5 people to be allowed to come in and say the accusation is not only true, but he did it to me as well. That's pretty hard to overcome.
Well, in the Michael Jackson case, they brought in evidence that 5 other young men were molested. And the charges were pretty horrendous in that one. So walking in, nobody gave us a chance in that one. I mean, a lot of my colleagues told me not to take it. They said you can't win it, and the rest of your life and career you're going to be defined as the guy who sent Michael Jackson to prison. And I thought long and hard about it. I said, look, this is who I am, and this is what I do. And the same thing holds with Bill Cosby. I had people telling me, you've won a lot of cases. You won Michael Jackson, the biggest case of your life in terms of media attention and length. And why jeopardize it? And I said, this is who I am. This is what I do. And Bill Cosby deserves a fair trial and says he's innocent. He's proclaimed it from day one. And it was an honor to represent him.
So why don't we shift gears a little bit now and talk about your pro bono work in Alabama? I know you have 2 very, very, very famous cases down there that were capital murder cases. We talked a little bit about it last episode, but why don't you tell us a little bit about those cases now?
Well, about 20 years ago, or maybe even a little more, I came to the conclusion that I like to see things myself. I don't like to just read about what's going on in other places, about things that interest me, and I'd read a lot of horror stories about death penalty trials in the South, and I said to myself, I want to see some of this for myself. I want to see what really is going on. And I spread the word out to some friends and got a call one day from a lawyer in Washington, D.C., who's now a law professor, who said that she'd been to a conference, met 2 white lawyers from Birmingham who were defending a homeless black man in a high-profile death penalty case where the defendant was alleged to have murdered very beautiful white girl from a prominent family, and they were getting threats on their machines that they were nigger lovers and things like that, and they'd like to meet me. Would I be interested? I said, sure. So I flew down on my own dime, met them. We became instant friends. I agreed to defend the case pro bono with them. And that started my career in the Deep South. All of my last 20 years, I've been doing murder and capital murder cases free. I did do one capital murder case free in Mississippi. And it's been one of the high points of my career. I love going to Birmingham. I've met some very fine judges and lawyers, very fine people, honorable people, people doing their best to try and keep the system fair, and met some very honorable prosecutors. And it's been one of the high points of my career. I wouldn't give it up for anything.
Well, I guess I was curious about that. What was the legal community's reception of you coming in there? I mean, you say you've met some fine prosecutors and fine judges. I'm picturing in my mind, the guy from California, born in New Jersey, this liberal, West Coaster coming down to the South and telling us how we should be trying this case. Is that not how it was? Was it a different reception?
Well, not with the defense attorneys I work with. They were, because I did change in many ways some of the ways they were defending cases, and I did it in a very respectful, gradual way, and I discovered right off the bat they wanted to know everything I thought about how to defend these cases. So the lawyers I worked with were extraordinary and decent human beings and very receptive. Some prosecutors did try the home cooking type thing with me. It didn't work. My attitude towards myself is just go in and be you, no more and no less.
Sure.
People will know if you're authentic or not. Sometimes the most theatrical, bombastic, dramatic lawyers are the least effective. Sometimes lawyers who are somewhat boring or deadpan or unemotional are very effective because jurors know they're authentic, they're real. So my attitude was always just be who you are and let the chips fall as they may, and we've done pretty well.
My dad says to me all the time, be comfortable in your own skin. I think that's the one thing he's always told me throughout my life.
Absolutely.
Yeah, I think that a jury, like I said before, they're observant. I think they can smell a phony, too. So can everybody else.
Sure.
Yeah.
Absolutely.
So tell me about the case involving the homeless man. When you get down there and you take this thing over, what's his approach to you coming in? Is he saying, boy, I'm a lucky guy? He's in jail, I'm assuming, right?
No, he was acquitted.
No, I mean when you went down and first met him.
Yeah. He was very receptive, very grateful, very nervous, obviously. We put him on the stand.
You did? Oh, I was curious. I think that the hardest evidence in that case was that there was an eyewitness, I guess, pretty far away who had said that they saw it, right?
Yeah, there were allegedly eyewitnesses and some physical evidence, but, we felt that the community wanted to solve this and solve it quickly because business was being affected. It was a trendy part of town where a lot of professionals, a lot of graduate students, college students go all the time. And, we got a not guilty. It was very controversial. The family of the poor girl who died was very upset. The father had to be restrained by bailiffs.
Was he upset? Did he direct that frustration at you personally?
Some of it. How
did you respond to that?
My heart went out to the family. I understand their reaction. It was actually some other relatives were pointing at me in the courtroom after it. They were furious because they believed the police. They thought our client was guilty. I don't blame them for being distraught and upset. My heart went out to them. I didn't hold anything against them at all.
Yeah,
not one bit.
We're a lot of times viewed as an extension of our client, even though we're not. We're different people. But I know I saw a clip of him bad-mouthing you on YouTube, and I just was curious how do you treat that when you're in the courtroom, when the emotion's being fired at you? And it's part of our job, obviously, but how does Tom Mesereau deal with it?
I don't take it personally. This is part of the business. were not always the most popular people, as you just described. And my heart still goes out to them. These people were devastated by the death of their beautiful, professional, highly educated, wonderful daughter who was studying to be a paralegal. It was just horrendous.
Yeah, terrible story. Did they ever find another suspect, or that was the end of it?
That was the end of it, as far as I know.
Yeah, so you had the lack of closure on that end, too.
Sure.
What other, tell us about another capital murder case down in the South.
Well, there's one I was especially proud of. It was the third one my friends and I tried. A guy had been on Alabama's death row for 6 years, a guy named Wesley Quick. He had been convicted of a double murder and got the death penalty. The convictions were reversed on a pure technicality. There'd been a mistrial in a short period of time, originally, and a transcript that was hardly had anything in the transcript was not given to the defense, and a pure technicality was reversed. My friend Charlie Salvaggio asked me if I would come down and defend with him. I said I would, and we had a retrial and acquitted him. And that's in the National Register of Exonerations, a compendium that's put together by the University of Michigan Law School in conjunction with Northwestern University Law School. I'm very proud of that. That was another emotional case. Grisly murders. 2 innocent young men just shot to death for no purpose. A lot of evidence of drug use, devil worship, things like that. Put the client on. He turned out to be a very good witness. He admitted he hadn't been truthful in the prior trial and just looked at the jury and explained who he was and what he did and what he did not do. And they came back, acquitted him. And there was a nice editorial in the Birmingham News about how we've got to be careful to make sure injustice doesn't infect our courtroom. Very favorable editorial to us. So I'm very proud of that one. But we've done a number of other ones, too.
That's just back to the Quick case. It seems to me that's pretty courageous to put a client on the stand who was going to need to admit that he lied in the first trial. I mean,
yeah, but again, when I got to Alabama, nobody was ever putting their client on the stand. It was almost an unwritten rule. You don't put them on. You don't make them a target for the prosecution. And I said, look, I don't agree with that. I think there are some cases where they have to see and feel your client and listen to what they have to say.
Yeah.
And this was a case where I felt he really had to get up and let the jury know who he is and what he said and what he didn't say and what motivated him, and it worked out. I believed him, and they did too.
How did he get thrown into the defendant's seat in that case? Did he have a relationship with the 2 men who were shot, or?
Not that I know of.
So you just
he claimed he didn't do it. It was a very, very ugly, gruesome case. The shootings were just horrendous. And they claimed he had been a devil worshiper, and they claimed he was there, and they claimed he was using all sorts of drugs, LSD and cocaine and other drugs, and they really tried to dirty him up. And fortunately, the jury went with it.
And your defense was that just outright, my guy was not the guy. You got the wrong guy.
Well, they had a witness against him who I tried to turn, in our direction, and I think the jury thought he was the one.
Oh, really?
I don't really know because I didn't talk to them. But, I thought we did a real good job on cross, and I thought Wes did a great job on the stand.
What's the most powerful part of a trial to get your message across? Is it during an effective cross, or is it during your opening, closing? What do you think?
Well, I think human beings have a tendency to make up their mind quickly.
Yeah.
That doesn't mean they can't change it, but it takes a little bit of doing to change it. So knowing that first impressions are important, I think you've got to just attack from your opening statement on.
Which goes back to not sitting back and taking a passive approach.
No, and I never waive opening statements. Just something I will not do. My view of a trial is, you tell your story in an opening statement, you tell your story in your cross-examination, you tell your story in your direct examination, and you tell your story in your closing argument. You tell it 4 times. You know, you use your judgment when you're doing it. You don't ask the same question of every single witness if there's no rational or logical reason to do that. But given whatever segment the witness can occupy, be it cross or direct, you are telling your story again and again and again. In fact, there's Jeffrey Toobin, the lawyer-author, wrote a fantastic book about the O.J. Simpson case called A Run of His Life.
Great book.
And that became the basis for the FX series a few years ago on the Simpson trial.
Yep.
And there's one page in that book where Toobin says he's watching Johnny Cochran, the defense attorney, the greatest trial lawyer I ever saw, cross-examine, and he doesn't think Cochran is making any headway. And all of a sudden it dawns on him, Cochran doesn't care what the answers are. He's talking to the jury through his questions.
He's telling a story.
Yeah.
Yeah. Do you have a theme before you start your trial?
Yes. I try to, reduce to a very, very short sentence or paragraph what exactly we're trying to show. And try to simplify it as much as possible, make it clear, make it clean, make it easily understood, and bang that drum throughout the trial. It's not easy to do, particularly in some of these white-collar cases where you're deluged with documents and material, but you have to.
Mm-hmm.
You've got to make sure the jury has a clear understanding from day one what you're there to tell them.
Does it change sometimes? And if it does change, how do you respond to it?
If it changes, it changes. I might even get up in closing and say, when I entered the courtroom, this is what I thought. But look at what we found out. Look at what we heard.
You just own it.
Too.
You just own it.
Yeah.
Yeah. I think that goes back to your credibility thing. You can't try to be something you're not. You can't have your case try to be something it's not.
That's right.
All right, Tom. Well, one last thing. Let's talk a little bit about your legal clinic in Los Angeles. You started that. It's in your namesake, right?
Well, yeah. It's called the Mesereau Free Legal Clinic. It operates at a church in South LA, which is one of the poorer communities. I've been volunteering at church-run free legal clinics in LA since the early 90s.
How do you finance it?
Well, it's hand-to-mouth, really. I'm not the greatest guy with money, and I'm certainly not a very good fundraiser. So we're kind of hand-to-mouth. I donate. We get friends to donate when they can. But it's kind of a hand-to-mouth operation. It meets 2 Saturday mornings every month. Lawyers, law students, college students, activists, and judges come by to help people with legal problems.
That's great.
We do expungements. We've had many people have their records expunged so they could get a better chance for a job, etc. We have special lecturers who talk about whatever it is, family law, wills and estates, the drug laws, criminal law, expungements, you name it. We have one federal judge in Los Angeles who comes quite a bit. He just loves to sit and try and help people any way he can. And we do our best.
That's great. It's a remarkable effort. You're right. Hitting the street with expungements and things that people may not know that they're eligible for, it can help everybody. I mean, those people can go get jobs, maybe be able to vote, everything. It's really a great mission that you have down there.
Well, thank you. We really enjoy it.
So I'll give you a chance to say any parting words. You've given us a lot of your time. I greatly appreciate it. Anything else you want to tell our crowd?
Well, I think that there's nothing greater in life than to be a criminal defense lawyer, to be an active trial lawyer. I thank God every day that I found this profession. I always say to law students when law schools ask me to come by, I say, if you're a loner, a rebel, and a misfit, you'll fit right in.
There's probably some truth to that. Well, thanks, Tom. I really appreciate being on the show. Maybe we can get you on again one day and talk about another one of your great cases. Maybe Mike Tyson, right?
Thanks for having me. Yeah, we kept him from being prosecuted that time.
That's right.
That's right.
All right.
Thanks for having me. I really have enjoyed it and feel honored and be happy to be on again. Thank you.
All right, that's our show. I hope you enjoyed Tom Mesereau. He's really a remarkable lawyer. He is the type of guy who refuses to take a shortcut. He works his butt off on his cases. I was interested to hear how he prepared. and it was relentless. And that goes to show how he was able to have such a wonderful result in the Michael Jackson case, which in my opinion could have been an absolute loser for a lot of other attorneys. And he's right, lawyering is an art, it is not a science. You do not get the same result for every lawyer. You will get a different result depending on their strategy and their work ethic. And Tom is an example of that. So it'll be interesting to see where the Bill Cosby appeal goes. Sounds like there's certainly a lot of ammo. But I mean, the guy's old. He's sitting in jail. It would be hard to believe any appeal would be granted and a new trial given to him before a couple years are up, and that's not good for him. So, interesting case, interesting dynamic. Enjoyed having Tom on the show. As I indicated at the beginning of the show, I don't know what's next, but it's going to be something exciting, I can promise you that. I was thinking about having my dad on the show. I know that's a little cheesy, but to me, he really is one of the best lawyers I've ever seen, and I've studied a ton of lawyers, and he's got a pretty cool story to tell. He represented a young woman who spent a lot of time in jail for a murder that ultimately she was basically defending herself, and it took 2 trips to the Supreme Court and my dad reopening the file to get her justice. And she ultimately did get that. It's a remarkable story, and I think I'm going to get him on and tell that. Selfishly, I think it's going to be something fun for me to do, and I think you guys will dig off the energy, and it'll be a really fun listen. So maybe that'll be next. Maybe it won't. I don't know. Stay tuned. As I always like to do, I like to thank a couple people for listening and giving me their support. One of them is Brad Billheimer. He is the prosecutor in Ocean County, and he's a good buddy, and he's a great lawyer, and he loves to listen to the show, so I wanted to shout out Brad. I'd like to shout out Amanda Wolf. She always listens, gives me her good feedback, and I'd like to shout out Benton Martin, who I don't know, but he's on Twitter, and he put us on his top 10 favorite podcasts of 2018 with a bunch of other podcasts that I have no business being in the same list with, including Serial, Crime Town, In the Dark, and a couple other great podcasts that I'm a huge fan of. So I was really stoked to be on that list, and it got a lot of traction on Twitter with people kind of saying that they agreed with the list, and to be on that list was really cool. So thank you, and I wanted to give you a shout out on the episode. So I hope you've enjoyed Under Oath as a show. If it continues, awesome. If it doesn't, it's been really fun. Thank you all for your support, and hopefully we'll see you next time.
We hope you enjoyed this episode of Under Oath. Please join us in the next episode for another look inside America's most famous cases with the people who tried them. To find out more or to see a video and pictures from each episode, go to underoathpodcast.com. You can follow us on Twitter at UnderOathPC. Today's episode was brought to you by the Lomurro Law Firm. Production of today's podcast was done by Jersey Shore Reporting. Tune in next time and find out who will be put under oath.